All right, Mr. Weiss. You may begin.
Good afternoon, Your Honors. May it please the Court. My name is Samuel Weiss. I represent the appellant, Charles Epley. The District Court made a series of unequivocal and decisive errors in granting judgment to defendants on the three claims that we raise on appeal, and those errors compel reversal. First, in the context of medical care, Charles Epley brought two medical care claims. The District Court granted summary judgment to defendants largely on the grounds that it had already dismissed almost all of his case on a Prison Litigation Reform Act screening order. That simply was not true. The screening order let his claim go forward in the entirety. So that is to say, the District Court never addressed the merits of his Eighth Amendment medical care case. On his failure to protect claim, the District Court granted summary judgment to defendants on the grounds that he had failed to establish a physical injury. The first issue with that is that he had, in sworn testimony, said that he had been brutally attacked 4 times over the series of 10 days, which is a sworn testimony that the District Court ignored. But perhaps even more fundamentally, the Prison Litigation Reform Act has a physical injury requirement that does not apply when the plaintiff files his case when he is no longer incarcerated. The District Court remembered this, that the PLRA, it applies sometimes, doesn't apply others. The magistrate judge tried to dismiss his case, Epley's case, on exhaustion as well. The District Court caught that mistake by the District Court. It didn't catch the mistake on physical injury. On religious liberty, the District Court had 2 bases for its decision. One is that the Celtic cross that was seized from Mr. Epley was contraband. That's not true. It's actually uncontested that it was not contraband. It was approved by his warden and by his chaplain. And also that he had other means to practice his religion. Again, it's just a flatly incorrect. He had no other means to practice his religion.
Did they ever locate his medallion?
No, they did not, Your Honor.
I didn't understand the allegation that he had to have that physical medallion to exercise his religious rights.
Yes, it's so he has sworn testimony as to that, to the importance of the medallion, because he was. I'll confess that I'm not a theologian here, but his sworn testimony, and defendants don't contest the sincerity, was that something about the cross gave him comfort and solace, and he ended up lacking this cross indefinitely, but perhaps most importantly, while he was transferred to the Montfort unit and was brutally assaulted. So again, sort of a flat error by the District Court. And finally, those are the 3 claims we bring on appeal, and finally we have this issue of transfer and severance. And again, just an unequivocal error by the District Court. The District Court, sua sponte, before defendants had even entered the case and over the objection of Mr. Epley, severed and transferred his case into 3 separate claims. It did so, the order doing so, that's at 359 and 360 of the record, paraphrases instead of quoting the federal venue statute, which is 1391, and misparaphrases it in a very fundamental way. It says that venue is wrong unless all defendants reside in a district, which of course is not true. It's whether any defendants reside in a district. And on that ground, severed his case into 3 separate claims pursuant to 1406A, which is the mandatory venue statute, the mandatory transfer statute, even though the mandatory transfer statute didn't apply because only the misreading of 1391 led the District Court to that conclusion. So again, with all the 3 claims he raises and his initial transfer, we just have clear errors from the District Court. The defendants largely don't defend the District Court's conclusions because it's difficult to. They argue for affirmance on alternative, variety of alternative grounds. But those 2 should be rejected in that they largely rely on encouraging this court to take defendant's versions of facts and not Mr. Epley's, when of course this is an appeal from a grant of summary judgment, and material disputes of genuine fact exist on all three of his claims.
What relief is your client seeking since he's out of jail now?
Yeah, so he's seeking to move forward on his damages claims for his three claims.
Damages?
Yes, Your Honor. Yes, Your Honor. So as you correctly point out, even by the time he had filed his case, he was out, and so therefore any equitable relief would have been mooted under this court's doctrine. So damages claims for his three claims.
Does this court have jurisdiction over the transfer order from the Northern District?
Yes, Your Honor. Why? It's plainly in the record of the case. Defendants certainly have never raised any sort of jurisdictional issue. It's
A transfer order appeal is usually through a writ of mandamus.
Yes, Your Honor. He did not file a mandamus. This is an incarcerated pro se plaintiff. I'm not sure if he was aware of the mechanism of mandamus, but he did not file a petition for mandamus, which of course is an extraordinary remedy. It is true that as defendants raise this as a practical point, and it's well taken that that undoing a severance and transfer order several years down the road is a big hassle to the parties and to judicial economy. The issue is that that's inherent to the district court's mistake here. So when the district court, venue, it's not jurisdictional, it's not an Article III issue. It tends to be pretty pragmatic. It can objections to it can be waived. It's what makes sense for the parties. And here we have a circumstance where a district court not just transferred, but severed before defendants had even entered the case. There wasn't even Prison Litigation Reform Act screening had not taken place here. So it wasn't even clear who the defendants were going to be. The defendants had no awareness that this case even existed. And Mr. Epley promptly filed a motion for reconsideration explaining that the facts of these three claims are intertwined and asking him, a pro se plaintiff with a variety of, a traumatic brain injury, psychiatric disabilities, to litigate claims related to a sequence of events that are intertwined and that occurred in a very short period of time, about 3 weeks, asking him to simultaneously litigate the same issues, not the same issues, but overlapping issues 3 times would be extremely prejudicial to him and also really undermine judicial economy. So Mr. Epley didn't have the ability outside of mandamus, which again is an extraordinary remedy. It's not like he had, there's some sort of exhaustion principle, certainly none that defendants cite in their briefing, that he had to seek mandamus. It was inevitable that there were going to be years of litigation in the separate cases before he would ever have appellate jurisdiction, before he could ever get to a final judgment to bring it up to this court. And now that he's here and is presenting it at this court, the question is was this order an abuse of discretion? And the answer is, of course. Stating a clearly incorrect legal conclusion, that's an abuse of discretion. It's black letter, this court says it all the time. In Re Volkswagen, they said it in the context of transfers. It stated the law incorrectly, it applied the law to the facts incorrectly. Defendants say, well, under 1404A, which is the discretionary transfer statute, he could have, the district court could have engaged in a discretionary transfer. The first issue with that is that the district court did not engage in a discretionary transfer. The district court didn't exercise any discretion at all because it mistakenly thought it had to mandatorily transfer the cases. And it's on 360 on the record on appeal, it's crystal clear, applicable to 1406A, transferred. It repeats that 3 times. which is the mandatory transfer statute. But even if we were to get into the factors, and this is a line from, there's two sets of defendants' briefs, there's an identical line copied and pasted from them, from both, that says the court must analyze 4 public interest factors, 4 private interest factors. The district court didn't analyze the 8 factors, nor did it mention the 8 factors. And also, another thing defendants ignore is that this isn't just a discretionary transfer, it's also a severance, which is really the core of the burden by splitting his case into 3. And we know from this court's opinion in re Rolls-Royce that it's not just those 8 factors kind of hovering over it. The main factor is judicial economy. And did it make sense as a matter of judicial economy to make the state of Texas and to make a pro se plaintiff litigate about the same series of issues in 3 separate districts across the state of Texas? And we know the district court didn't answer that question at all because it didn't think it had to. But if it had to answer the question, we think the answer is of course not. And it would nonetheless have been abuse of discretion, even though we don't think the panel even has to reach that. If I may, I'm happy to answer about any of the substantive claims. To address, my friend on the other side filed a 28J letter yesterday that I think just to discuss Mr. Epley's religious liberty claim briefly, I think the case she has cited really explains why this court is compelled to reverse on his religious liberty claim. So she cites a 2022 opinion, DeMarco versus Bynum, but that case actually went up to this court twice. So this is another incarcerated plaintiff in the state of Texas who had religious property of his seized. In that case, it was a Bible, but the situations are quite analogous. In fact, in his complaint, he said his Bible was seized by a staff member who said, this is in DeMarco, something along the lines of, this is our prison, we get to decide what you have and what you don't. In this case, if you look at the record on appeal, 3095, 3096, we have contemporaneous statements by Epley that Officer Robinson said, you better not be bringing this religious stuff inside my prison. So the cases are really on all fours. And that case was dismissed by the district court. It went up to this court in 2019 with a different title, DeMarco versus Davis. And this court, in an opinion written by Judge Smith, reversed and said his religious paraphernalia was seized and destroyed, and we need to gather some evidence on whether it satisfies the Turner versus Safley test, which is a rational relationship to legitimate penological goals, which is deferential to prisons, but not unquestionably so. And then it went back down, and the defendant said that, in fact, it was uncontested that he had been storing, the plaintiff in that claim, DeMarco, had been storing his Bible inappropriately in violation of Texas's rules, and the defendant said, this is why we seized his Bible. This is why we destroyed it. And this court analyzed that basis and said, is enforcing the prison storage rules, does that satisfy Turner versus Safley? And this court said yes. So we have one reversal and we have one affirmance. And this case on summary judgment is on all fours with the reversal, not with the affirmance. Because what we have here is he has a Celtic cross. Again, it's not contraband. It was approved by the chaplain. It was approved by the warden. We have an officer seizing it on grounds that you better not bring this religious stuff inside my prison. I'm using a euphemism. And it was never returned to him. So there is no reasonable relationship to any legitimate penological goal per the evidence in the record. It's just taking Mr. Epley's version of the facts as we must. It was just pure religious hostility, which does not further any legitimate penological interest. I'll reserve my time if there are no further questions for rebuttal.
All right. Thank you, sir.
Thank you, Your Honor.
All right. Ms. Jackson? May it please the court. Mr. Epley's claims fail for at least 3 reasons. First, Mr. Epley's first free exercise claim fails because the prison policies at issue in this case are reasonably related to legitimate penological goals of safety and security. Second, Mr. Epley's medical care claim fails because he was provided treatment responsive to his needs. And third, Mr. Epley's failure to protect claim fails because the Line-Aw unit, where Mr. Epley suffered no use of force event, did not objectively pose a substantial risk to serious harm. And regardless, the Line-Aw officials made the reasonable decision to maintain Mr. Epley's single-cell housing assignment. This court should affirm the district court. Now, Your Honors, before we jump into the merits of this case, I do want to address 2 threshold issues off the top. The first is that the state is not asking this court to accept our facts, as my friend on the other side of the aisle indicated. For the purposes of this argument, we are, of course, up on summary judgment, and we take the facts in the light most favorable to Mr. Epley. The second issue is an issue that Judge Clement brought up, the transfer issue. As Judge Clement indicated, mandamus petition is the correct vehicle for a transfer order review.
But you didn't object.
We did not object, and in fact, in Mr. Epley's amended complaint, he also did not object to the venue transfer. He indicated that venue was proper in the new district. So for the reasons that we've already discussed here, the Volkswagen case, the Rolls-Royce case, the Itie Planned Parenthood case, mandamus is the proper avenue there. My friend on the other side spent several minutes talking about the transfer. Unless there are further questions, I'd like to transition to the merits of the discussion. Your Honors, Mr. Epley's free exercise claim fails because he cannot satisfy that any of the 4 factors under the United States Supreme Court, Turner versus Safley, have been satisfied here. Turner versus Safley requires that a prison policy be reasonably related to legitimate penological goals. Applying Turner to the facts of this case, we must consider whether there was a rational relationship between the prison's policies of offender property and confiscation related to the goals of maintaining safety and security within the prison context. The remaining 3 factors also require us to consider whether there were alternative means for Mr. Epley to actually exercise his religion, whether there would be any ripple effects on the remaining prisoners, the inmates, and the rest of the prison resources to accommodate his exercise, and whether there are ready alternatives that could have fully accommodated Mr. Epley's free exercise. Of these 4 factors, Your Honor, the court has said that just one is dispositive, the rationality prong. That's the first one. So I will focus on that today. When we're discussing rationality, this court has recognized a presumption in favor of rationality. And this court does defer to prison officials when they are making decisions about policies that affect their prisons. A policy is not rationally related to a legitimate penological goal only if it is so remote as to render the policy arbitrary and irrational. And we know what this looks like, Your Honors. In the Supreme Court case of Turner, the court struck down a prison's marriage rule that prevented inmates from getting married because the prison's stated goal, preventing love triangles, was too remote from the regulation. The court determined that effectuating wedding ceremonies was going to pose a de minimis burden on the prisons, so ultimately the rule was arbitrary. And it also reasoned that romantic relationships, of course, exist outside the bounds of marriage, so the rule was also irrational. In contrast, the same court in Turner did uphold a prison's inmate-to-inmate mail ban because the evidence showed that passing notes between inmates amongst the prison did increase gang activity and violence, it increased trafficking of contraband, and it required prison officials to have to censor and go through mail piece by piece. This was obviously a burden on the prison. The rule was not arbitrary, and it was not irrational. Your Honors, applying Turner, this court frequently holds that prison regulations impacting an inmate's religious exercise are rationally related to a prison's valid goals of safety, security, property maintenance, and prison operations. And when it comes to regulating religious devotional items, like the medallion in this case, this same court has upheld prison regulations impacting prisoners' possession of those items, even if those items, as Judge Clement pointed out earlier, are alleged to be necessary to the prisoner's exercise of their faith. These types of items include the religious books that my friend on the other side of the aisle discussed in the DeMarco case. They also include medallions very similar to the Celtic medallion at issue in this case, and they include rune stones that were at issue in the Mayfield case. And the court has consistently upheld prison policies regarding the confiscation and possession of prisoners' personal items as not violative of the Free Exercise Clause.
So what if this had been a Christian cross necklace?
It would not matter what the religion was as long as the prison policy was applied neutrally, and in this case, there's
What's the penological interest in seizing that?
The penological interest would be tied to the prison's policy regarding confiscation of materials. Prisoners, of course, are able to exercise their First Amendment rights within the prison context, but those are necessarily limited based on the security concerns within prisons.
So, but let me ask again, what's the security concern with
The security concern with confiscating any piece of prisoner property would be whether or not the prisoner had the ability to have that property. That is often brought into question when inmates are transferred between units, as Mr. Epley was here, and when inmates are being seen in medical or hospital environments, again, as Mr. Epley was here. So
I'm sorry, is it the state's position that an inmate's Bible and an inmate's cross necklace, they can be taken, and all the state has to do is say that we have a security interest?
The state's position is that the prison's policy regarding confiscation does allow for the confiscation of materials at any time in regard to a security concern. Those are often heightened in the case of when an inmate is being moved between prison facilities or if the prisoner is being seen by medical personnel. So the state does not indicate that you can take religious items or any item and just state that it's a security concern, but to the extent that the policy is rationally related to those security concerns, then the policy should be upheld for those.
Well, there are two potential concerns here. One is, even assuming a neutral policy, the whole point of the Free Exercise Clause is to protect religious exercise in particular. Second, there is an allegation, as I understand it, that this was not neutral. This was, I think counsel referred to this as evidence of religious that there was evidence of religious hostility.
I understand Your Honor's question. To that point specifically,
In other words, if we accept your theory, what's to prevent prison staff from simply going around and taking all manner of religious items?
Well,
and then reciting this interest that you're talking about. It seems like this argument would apply to anything.
Respectfully, Your Honor, I don't believe that is the case that we have before us, but I would encourage...
What's your limiting principle here?
Well, I would encourage the court to look to its decision in the McFall case. That case also included some colorful language when the religious material was being removed from the individual. That case also included a Celtic religious medallion. And ultimately, the court did not grapple with those issues and was able to decide that the policy should be upheld, despite the fact that there was some colorful language being used.
Let me ask you, why was he transferred so many times, sort of back to back? I mean, what was going on?
Your Honor, the record indicates that there were some undisclosed medical reasons as to why he was transferred initially. We do know that the Montfort unit includes a psychiatric facility, so I believe it's reasonable to assume that he was being moved for a psychiatric evaluation. Aside from that, the record does not really speak to why the transfers were initiated. I do believe that it's relatively common for an inmate to be held overnight in a unit if they are moving across the state to a different unit. Aside from that, the record is silent on that issue, Your Honor. Now, I do want to point the court's attention before we move on from free exercise to the fact that in the DeMarco case, this court did uphold the exact same policy that's at play here. That is the TDCJ's Offender Property Policy AD 03.72. So in this case, all we are asking the court to do is to affirm what it already did in DeMarco uphold that same policy because it is rationally related to legitimate penological interests in safety and security.
So for purposes of these proceedings, you're accepting his facts as given that his religious symbol was taken, was confiscated?
For the purposes of this argument, Your Honor, we will accept that as given. Now, I'd like to move on to Mr. Epley's deliberate indifference claims, Your Honors. He brings two deliberate indifference claims. The first is related to his medical needs. And again, we're going to assume, for the sake of this argument, that he did have a serious medical need. But he did fail to show that that medical need was ignored by medical professionals within the prison context.
What treatment did he receive?
Of course, Judge. He received treatment from Mr. Itie. He was cared for the day that he reported his injuries at the line-on unit. Mr. Itie evaluated Mr. Epley that same day, and he scheduled a follow-up visit with Mr. Epley to evaluate the treatment that he was receiving within 4 days from that initial visit. Mr. Epley immediately administered antibiotics. He immediately ordered x-rays. He immediately prescribed a tailored pain medication plan for Mr. Epley. He continued to monitor and adjust Mr. Epley's treatment plan based on Mr. Epley's own feedback. And he adjusted Mr. Epley's work orders to limit him to lifting no more than 30 pounds. And he did recommend lower bunk only access for Mr. Epley. These facts showing that Mr. Itie did care for Mr. Epley are very consistent with the many cases that this court holds where there has been adequate treatment of care. The rare examples where this court has held that there's deliberate indifference in this context are much different. In the Carlucci case, for example, the court determined that dentists within the prison system did act with deliberate indifference toward an inmate who was experiencing tooth pain. The recommended care for that inmate in the case would have required restoring the dental bridge and repairing his fractured teeth. The dentist did no such thing. In fact, they provided no treatment at all, and then indicated at court that he could have had his teeth pulled. In that case, the inmate was only seeking the recommended treatment that was available to him, and that was denied. So too in the Easter case, Your Honors. There, a nurse refused to dispense an inmate's prescribed medication, despite knowing that he had a standing prescription, despite knowing that he had a heart problem, and despite knowing that he was experiencing chest pains at the time when he asked for his medication. She instead sent him back to his cell with no treatment at all. Again, that's very different from the case that we have before us. Your Honors, under this court's cases, each of the facts regarding how Mr. Epley was treated, the evaluations, the examinations, his continued treatment, and ultimately Mr. Epley's refusal to follow the treatment plan and decline the x-rays, all of these facts rebut a deliberate indifference claim. Now, Your Honors, I'd like to turn briefly to Mr. Epley's second deliberate indifference claim. That one is related to his failure to protect claim. Mr. Epley's failure to protect claim also fails because he did not show that he was incarcerated under conditions that objectively pose a substantial risk of serious harm, or that any line-law official displayed deliberate indifference toward his health or safety. The deliberate indifference standard, again, is an extremely high standard. It's the same standard that we use for the medical needs claim. The prison official must know about a substantial risk of serious harm and that he recklessly disregards. For this claim, Mr. Epley sued the line-law medical and prison personnel for the time that he was at the unit from June 9th to June 23rd. This would have been after the use of force incident at the Montford unit. When he returned to the line-law unit, Mr. Epley immediately met with Ms. Ingram, and Ms. Ingram indicated that he should remain on his single-cell housing assignment despite not thinking that there was a substantial risk. For these same reasons, even if the line-law unit objectively did pose a substantial risk, Mr. Epley has not shown that the line-law officials were deliberately indifferent to it. They did provide him housing, and while he did ask for safekeeping housing, safekeeping housing is not a long-term option. It's not ideal for inmates. and the single cell is consistent with the care that he had been provided previously. Now, Your Honors, before I conclude, I would like to touch on qualified immunity because each of these individuals are entitled to qualified immunity here. Mr. Epley did not show that there was a violation of a clearly established constitutional law. In the free exercise context, a known violation of an inmate's constitutional rights would be a policy or regulation that is so remote as to be arbitrary or irrational. This would look like the marriage rule in the Turner case. And in the deliberate indifference context, a known violation occurs if an official refuses to treat an inmate, ignores his complaints, intentionally treats him incorrectly, or otherwise recklessly disregards a risk of harm. This would look much more like the Carlucci or the Easter cases that we discussed. And even if Mr. Epley could show that there was some known violation of a constitutional law here, he cannot show that the conduct of the officials in responding to that was unreasonable. As discussed, the removal of his medallion and the medical treatment and the housing assignments that he received all reflect a reasonable response given the policies and the safety and security concerns of the prison context. Your Honors, if there is no further questions, I'll cede my time.
All right, thank you. Back to you, Mr. Weiss. You have any rebuttal?
Thank you, Your Honors. I'll start briefly with the transfer. He did object to the transfer. He filed a motion for reconsideration. That's back in the Northern District. And then he also objected over in the Western District. These are both cited on page 19 of our brief. Also, to defendant's point about mandamus, the word mandamus does not appear in either of defendant's briefs. Again, they got two bites at the apple here. There are two sets of briefs to Mr. Epley's initial case, two sets of briefs to our opening brief. I understand defendants have brought in excellent counsel to argue this case, but defendants obviously have to make their arguments in their briefs and not at oral argument. On the religious liberty claim, pardon me, Judge Clement. Okay. On the religious liberty claim, again, the cited policy that defendants evoke from DeMarco does not appear in either of their briefing. DeMarco does not appear in their briefing. It came in a 28-J letter yesterday. However, the issue is not the policy. As Judge Ho described, the issue is the individual's conduct here. In the qualified immunity context, too, she described First Amendment free exercise rights as being solely challenges to policy. Turner versus Safley, that did include two challenges to policy, but the free exercise right, as are other First Amendment rights, also can apply to individual acts of defendants, and that's what this claim is. It's that two defendants acted out of animus to deprive him of his religious liberty rights, and the question is, were there actions, not the policy, were there actions in a reasonable relationship to a legitimate penological goal? Taking Mr. Epley's facts, of course they were not. To Judge Clement's question, why was he transferred 7 times all across the state of Texas after Mr. Epley is quite a vulnerable individual. He has traumatic brain injury, he has psychiatric disabilities, he was very badly beaten. He spent roughly 2 decades in the same prison in a relatively calm state of affairs, and then in 3 weeks he was transferred 7 times and had a series of brutal things happen to him, which led to the events that required this court to reverse the district court in the Northern District last year, and the cases before us here too. Mr. Epley has no idea why this happened. He's never been given any kind of explanation. To Mr. Epley's medical care claims, an important thing to remember here is that Mr. Itie, the defendant Itie, is not a physician. He confirms, we can take Mr. Epley's contemporaneous statements as well as his sworn statements, but Itie himself confirms, potential brain injury, but broken nose. This is, for somebody with a history of traumatic brain injuries, and that he had taken steps, including to contact the head, the executive medical director of the Texas Tech system, and then to give him a CT scan, and importantly, to make him see an outside physician, which Mr. Itie is not. And then all of a sudden, after a meeting with defendant Sellers, that treatment abruptly stopped, and instead he was ordered to take some Tylenol and go on bed rest, take a few days off. So deliberate indifference is indeed a high standard. He has nonetheless demonstrated it. And in contrast to something like, also in the 28J letter was Judge Ho's opinion in Gibson versus Collier, which involved a controversial medical treatment, and the opinion stated that it cannot be deliberate indifference to fail to provide a controversial treatment. This is the opposite of a controversial treatment. This is someone gets whacked on the head, and a low-level medical officer says, I think he needs to see a doctor. I think he needs to get some tests done. And then after a meeting with Sellers, abruptly changing his mind. And again, confirmed by contemporaneous grievances, confirmed by not Dr. Itie's own notes.
Just one last question about the free exercise. What is in the summary judgment record about the medallion and the free exercise claim? I mean, what's in there?
In there about the cross?
Yeah.
So another thing that the district court relies on is these inventory reports. So one of the things the district court said was that the inventory reports show that he never had the cross at all. And the problem with that is that there's an inventory report that shows that he has the cross on the 27th. And then there's an inventory report that says he doesn't have the cross on the 31st. This is the 31st of May. And then on June 2nd is where this alleged event occurred. So the district court said, these records aren't infallible. That's using the magistrate judge's words. But they seem to show that he never actually had the cross. The issue with this is that there's also a May 26th inventory report, and that also shows that he does not have the cross. So I'm sorry, I know this is all fast, but May 26th, the prison says he does not have the cross. May 27th shows that he does have the cross. May 31st, an inventory report says he doesn't have the cross. June 2nd, this event occurs with a lot of contemporaneous grievances saying on June 2nd, Mr. Robinson took my cross. And the the district court looked at that and said, somehow that overcomes 28 U.S.C. 1746 and says that, that is, again, described it as not infallible, but doesn't cite the May 26th inventory report, showing that it's not just infallible.
The record is essentially these various reports. That's what you're saying.
Yes, Your Honor. So there's inventory reports, which again we think are pretty clearly unreliable unless the Celtic Cross is like phasing in and out of existence day by day. And then we have.
I know what your free exercise claim is, but it's on summary judgment on just these reports. At best, what relief would you want in the point? A trial on that? I mean, what would be the basis of ascertaining what happened to the cross?
Well, Your Honor, he has his own testimony. He has his own records that are in the summary judgment record, contemporaneously explaining what happened to his cross, and defendants.
Okay, you just said that's a disputed fact, is what you.
Yeah, absolutely. It's a disputed fact for resolution by a fact finder.
Okay, I just want to be clear.
On the 28J, since it was filed yesterday, you haven't had a chance to respond yet, right?
I have not, and frankly, I've made my responses here, and
right.
And
just want to give you the chance.
I appreciate that. There's no
particularly on DeMarco.
I appreciate that. I've explained on DeMarco, frankly, also on your opinion and Gibson. So there's no argumentation in the 28J. There's just parentheticals. I've explained my thoughts on them. So I appreciate that from a procedural perspective, but I'm happy to submit on this argument if your honors are content with that.
All right. Counsel, you're appointed?
Yes, I'm appointed through the program.
Court appointed?
Your Honor.
Okay, I just want to be clear. Okay, well, to put it mildly, the court appreciates all of our court-appointed counsel who come in on cases. This one is particularly snarly and moving and weaving, and so the extent to which you have embraced it and briefed it and argued it, we appreciate as a panel, but as a court as a whole, when you take on these cases that the court appoints you to. So thank you.
Thank you very much, Your Honor.
All right, thank you, counsel on both sides. This concludes the orally argued cases for this panel. Those that were argued yesterday, along with the non-orally argued cases, will be submitted, and the panel stands adjourned.